"You don't belong here, sweetheart." Attorney Preston Kingsley's voice boomed across the packed Chicago Federal Courthouse as he dismissed the black woman adjusting the court reporting equipment. "Why don't you go find the real court reporter?" The 52-year-old woman paused, her fingers steady on the stenotype machine as Kingsley's laughter echoed through the marble chamber. Lawyers turned. Court staff froze. "I said move along," Kingsley continued, his voice dripping with condescension. "This courtroom is for professionals, not whatever you are." But as Judge Simone Whitmore calmly reached into her briefcase and pulled out a black judicial robe, Kingsley's smirk faltered. The documents on her desk weren't transcription notes. They were federal discrimination cases. 12 lawsuits, 12 careers about to end. Kingsley had just committed professional suicide against the one person in Chicago with the power to dismantle his entire career. What happened next would expose decades of institutional racism and prove that sometimes justice comes disguised as the person you underestimate. The morning sun cast long shadows across the marble steps of the Dirksen Federal Building in Chicago's Loop District. Inside courtroom 2305, the atmosphere buzzed with the quiet intensity that preceded high-stakes federal litigation. This wasn't just any Tuesday morning. This was the day that would reshape everything about how justice operated in the Windy City. Simone Whitmore arrived at 7:30 a.m., 2 hours before the scheduled hearing. She moved with the practiced efficiency of someone who had spent decades navigating the labyrinthine corridors of federal justice. Her modest navy blazer and sensible shoes gave no hint of the authority she commanded, or the explosive revelations she carried in her leather briefcase. The courthouse janitor, Miguel Santos, nodded respectfully as she passed. "Morning, Ms. Whitmore, you're early today." "Big day ahead, Miguel," she replied with a warm smile that transformed her serious features. "How's Maria's college application coming along?" "She got into Northwestern thanks to that letter you wrote." His voice carried genuine gratitude. "She starts pre-law in the fall." Simone's heart warmed. These were the moments that reminded her why she dedicated her life to justice. Not the headlines or accolades, but the quiet victories that changed individual lives. Little did Miguel know that by tonight, his simple act of treating her with dignity would stand in stark contrast to what was about to unfold. The courtroom itself was a testament to federal authority. Rich mahogany panels reached toward a vaulted ceiling, while natural light streamed through tall windows, illuminating the Great Seal of the United States mounted behind the judge's bench. The American flag stood at attention, its stars and stripes bearing witness to countless moments of justice and injustice. Simone settled herself at the court reporter's station, a modest desk positioned strategically to observe every interaction in the room. Her stenotype machine, a silent witness to decades of legal proceedings, sat ready to capture every word. But today, it would record something far more significant than standard testimony. At 8:15 a.m., the first attorneys began filtering in. Defense counsel Nathan Pierce nodded politely as he arranged his files. Assistant U.S. Attorney Jennifer Martinez offered a professional greeting. These lawyers understood courthouse etiquette, the unspoken respect for everyone who made the system function. Then Preston Kingsley arrived. Even from across the room, his presence commanded attention, but not the kind that inspired respect. His handmade Italian suit probably cost more than most court employees made in a month. His Hermes briefcase gleamed under the fluorescent lights. His gold Rolex caught every ray of sunlight, a deliberate display of wealth and status. But it wasn't his expensive accessories that made seasoned court staff exchange knowing glances. It was the way he moved through the space, like a man who had never been told no in his life, who viewed every room as his personal domain, every person as either useful or invisible. Kingsley's law firm, Pemberton, Ashworth & Associates, represented some of Chicago's most powerful corporations. Their client today was Midwest Financial Corporation, facing federal charges for discriminatory lending practices that had devastated Black and Latino neighborhoods across the city. The case had been building for 2 years, with hundreds of victims seeking justice for systematic redlining that had denied them home ownership and wealth-building opportunities. As Kingsley surveyed the courtroom, his gaze swept dismissively over the court staff. The bailiff, Marcus Sterling, a decorated Marine veteran who had served 3 tours in Afghanistan, received barely a glance. Court clerk Olivia Bradford, who held a master's degree in legal studies and had managed this courtroom's complex docket for 8 years, might as well have been furniture. But when his eyes landed on Simone, something shifted in his expression. Here was someone he couldn't immediately categorize, a middle-aged black woman in professional but unremarkable attire, sitting at equipment he didn't fully understand. In Kingsley's worldview, she represented everything he felt entitled to dismiss. "Excuse me," he called out, his voice carrying the casual authority of someone accustomed to being obeyed. "Are you the court reporter for this proceeding?" Simone looked up from her machine, her dark eyes meeting his with steady composure. "I'm here to ensure accurate documentation of today's proceedings, Mr. Kingsley." Her response was perfectly professional, but something in her tone, a subtle confidence that suggested depths he couldn't fathom, irritated him. In Kingsley's experience, court staff were meant to be helpful, deferent, and above all forgettable. This woman seemed to possess an inner authority that challenged his assumed superiority. "Well, make sure you keep up," he said with a condescending smile. "These cases involve complex financial instruments that might be challenging for someone like you to follow." The courtroom fell silent. Marcus Sterling's hand moved instinctively to his belt. Olivia Bradford's fingers tightened around her pen. Even the normally chatty attorneys stopped their conversations. But Simone simply nodded, her expression unchanged. "I'll manage just fine, Mr. Kingsley. Thank you for your concern." But what Preston didn't know about the quiet woman taking notes would destroy everything he believed about power. As the courtroom filled with spectators, Preston Kingsley's behavior became increasingly theatrical. He strutted between the counsel tables like a peacock displaying its plumage, making sure everyone noticed his expensive accessories and commanding presence. His voice carried across the marble chamber as he spoke loudly into his phone, discussing strategy with associates in terms designed to impress anyone within earshot. "Tell the partners I'm handling the Midwest financial matter personally," he announced, his voice echoing off the high ceilings. "These federal prosecutors don't understand the complexities of modern banking. I'll have this wrapped up by lunch." Simone continued her quiet preparations, adjusting her stenotype machine and reviewing her notes with the focused attention of a consummate professional. Her movements were economical, purposeful, the habits of someone who had spent decades in courtrooms and understood that real authority didn't need to announce itself. But Kingsley couldn't leave well enough alone. "You know," he said, approaching her station with the casual arrogance of someone who had never faced real consequences, "I've been practicing law for 15 years, and I've never seen a court reporter take so many preliminary notes. Are you sure you're qualified for a case this complex?" Several attorneys glanced up from their preparations. The question hung in the air like smoke from a fired gun, technically polite, but loaded with condescension and barely concealed prejudice. Simone looked up calmly. "I've been documenting federal proceedings for quite some time, Mr. Kingsley. I'm confident in my abilities." "Federal proceedings," he repeated with a slight smirk. "That's impressive. Though I imagine this case involves financial instruments and constitutional law that might be above your usual scope of practice." Marcus Sterling shifted uncomfortably near the witness stand. As a bailiff, he'd seen attorneys challenge court staff before, but rarely with such obvious disdain. His military training had taught him to recognize bullies, and Kingsley's behavior set off every warning signal he'd developed over years of combat and law enforcement. Olivia Bradford, organizing documents at the clerk's desk, felt her jaw tighten. She'd witnessed plenty of arrogant attorneys over her 8 years in federal court, but Kingsley's treatment of Simone crossed lines that even the most self-important lawyers usually respected. There was something deeper at work here, a fundamental disrespect that went beyond professional hierarchy. "I'm sure I'll manage to keep up," Simone replied evenly, her fingers returning to her machine with practiced ease. But Kingsley wasn't finished. Success had taught him that persistence in establishing dominance paid dividends, and something about Simone's quiet confidence irritated him like a splinter under the skin. "Don't take this the wrong way," he continued, his voice dropping to what he probably imagined was a helpful tone, "but these federal discrimination cases can be quite technical. There's extensive case law, complex statistical analysis, constitutional precedents dating back decades. I'd hate for transcription errors to compromise the record. The insult was expertly crafted, technically phrased as concern, while unmistakably questioning her competence. Around the courtroom, conversations stopped as lawyers and court staff registered the boundary Kingsley had just crossed. Attorney Jennifer Martinez, representing the government, looked up sharply from her files. In her 6 years as a federal prosecutor, she'd learned to recognize the subtle racism that pervaded certain corners of the legal profession. Kingsley's comments weren't just inappropriate, they were revealing a mindset that explained why cases like Midwest Financial's discriminatory lending practices existed in the first place. Defense counsel Nathan Pierce felt his stomach clench. He'd worked with Kingsley on previous cases and had witnessed his casual bigotry before, but never quite so publicly. Pierce had always told himself that Kingsley's comments were just misguided attempts at humor, but watching him target the court reporter with such obvious disdain made Pierce confront uncomfortable questions about his own complicity. Simone's response was a masterclass in professional composure. "Mr. Kingsley, I appreciate your concern for the accuracy of the record. You can be confident that every word spoken in this courtroom will be documented with complete precision." Something in her tone, a quiet authority that suggested vast experience with exactly these kinds of proceedings, should have given Kingsley pause. But his success had insulated him from consequences for so long that he'd lost the ability to recognize warning signs. "Well, I hope so," he said with a patronizing smile, "because when we win this case, I want to make sure there's no confusion about what happened here today." As he returned to his table, Kingsley felt satisfied with his performance. He'd established his authority, put the court staff in their proper place, and demonstrated to everyone present that he was the most important person in the room. In his mind, the morning had gone exactly according to plan. But as Simone Whitmore continued her methodical preparations, her dark eyes held depth that Preston Kingsley couldn't begin to fathom. The morning's interactions had been carefully observed and mentally catalogued by someone with the experience to recognize patterns of discrimination and the authority to act on them. As Preston's arrogance reached new heights, he had no idea he was digging his own professional grave with every condescending word. By 9:30 a.m., courtroom 2305 had filled to capacity. The Midwest Financial case had drawn significant attention from civil rights organizations, community groups, and media outlets covering the ongoing fight against institutional discrimination in Chicago's financial sector. Representatives from the NAACP, Urban League, and Fair Housing Council occupied the gallery's front rows, while local news reporters positioned themselves for optimal coverage. The case itself represented years of investigation into systematic redlining that had denied mortgages to qualified Black and Latino families across Chicago's south and west sides. Internal bank documents revealed explicit policies targeting minority neighborhoods with higher interest rates, discriminatory appraisal practices, and outright loan denials based on zip codes rather than creditworthiness. For the families affected, this wasn't just about money. It was about the American dream systematically denied, generational wealth prevented from building, communities deliberately starved of investment. The courtroom gallery held dozens of plaintiffs whose stories formed the backbone of the federal government's case. Preston Kingsley surveyed the packed courtroom with the satisfaction of a performer who had drawn a crowd. This was exactly the kind of high-profile case that built reputations and attracted lucrative clients. Win or lose, his aggressive defense of Midwest Financial would be noticed by corporate executives across the city. But the diverse crowd in the gallery clearly bothered him. These weren't the usual suspects who populated complex financial litigation: corporate executives, banking regulators, financial journalists. Instead, he saw working-class families, elderly homeowners, young couples who had been denied the chance to build equity in their own communities. "Quite a circus today," he commented loudly to his associate, deliberately ensuring his voice carried to the gallery. "I suppose everyone gets their day in court, even if they don't understand what they're here for." Several plaintiffs shifted uncomfortably in their seats. Maria Rodriguez, a nurse who had been denied a mortgage despite excellent credit and steady income, felt the familiar sting of condescension she'd experienced from bank officers. James Washington, a teacher whose application had been rejected for a home in his childhood neighborhood, recognized the tone he'd heard from loan officers who spoke to him like he was asking for charity rather than offering to pay market rates with interest. Simone observed these interactions with the sharp attention of someone who understood how institutional discrimination operated. She'd spent decades watching how power dynamics played out in courtrooms, how certain attorneys treated different groups of people, how the system itself could be weaponized against those it was supposed to protect. At 9:45, a commotion near the courtroom entrance drew everyone's attention. An elderly black woman, clearly struggling with mobility issues, was trying to navigate the crowded gallery with a walker. She'd arrived late, having traveled by public transportation from the south side, and was searching for an available seat among the packed benches. "Ma'am, let me help you," Marcus Sterling said, moving to assist her to a reserved seat near the front. But Preston Kingsley saw an opportunity to further demonstrate his authority and contempt for the proceedings. Rising from his chair with theatrical frustration, he addressed the courtroom in a voice loud enough for everyone to hear. "Your Honor isn't even here yet, and we're already turning this courtroom into a social services office," he announced, his tone dripping with disdain. "Perhaps we should establish some ground rules about who belongs in a federal proceeding." The courtroom fell deadly silent. Even the whispered conversations among attorneys stopped completely. This wasn't just inappropriate. It was a direct attack on the plaintiff's right to observe proceedings that directly affected their lives. But Kingsley wasn't finished. Emboldened by what he perceived as his audience's attention, he decided to make his point even more explicitly. "I mean, really," he continued, gesturing toward the gallery, and then turning his attention to Simone. "If we're going to maintain professional standards in this courtroom, maybe we should start by making sure everyone understands their role. For instance," he said, looking directly at her, "court reporters are supposed to be invisible and silent, not taking up space with unnecessary equipment and distracting preparations." Simone's hands stilled on her stenotype machine. Around the courtroom, lawyers, court staff, and spectators held their breath. They had just witnessed something that crossed every line of professional conduct and human decency. "Mr. Kingsley," she said quietly, her voice carrying clearly across the silent courtroom, "I understand my role perfectly." But Kingsley, intoxicated by his own sense of superiority and encouraged by what he misinterpreted as submission, decided to deliver his coup de grace. "Good," he said with a satisfied smirk. "Because frankly, sweetheart, I'm not sure you have the background or education to handle a case of this magnitude. Maybe stick to personal injury cases where the legal concepts are more appropriate to your level." The insult hung in the air like a toxic cloud. Several people in the gallery gasped audibly. Attorney Jennifer Martinez dropped her pen. Even Preston's own associate looked mortified by the blatant racism and sexism of the comment. But as Simone Whitmore slowly rose from her chair, something in her posture, a quiet dignity that suggested vast reserves of strength and authority, made everyone in the courtroom lean forward. What happened next would expose a truth so shocking that it would change everything Preston thought he knew about power, justice, and the woman he had just made the mistake of underestimating. The silence in courtroom 2305 stretched like a held breath. Preston Kingsley's insult had crossed every boundary of professional conduct, human decency, and legal ethics. But instead of the cowering response he expected, something extraordinary was happening. Simone Whitmore stood slowly, her movements deliberate and dignified. There was no anger in her posture, no defensive reaction to the racist and sexist attack. Instead, she possessed the calm authority of someone who had faced far greater challenges and emerged victorious. Her dark eyes swept the courtroom, taking in every face, every expression, every witness to this moment that would change everything. Marcus Sterling, the bailiff, felt his training kick in. 20 years of military service had taught him to recognize leadership under pressure, and something about Simone's composure reminded him of commanding officers who possessed unshakable authority. His hand moved instinctively to his radio, but he hesitated, sensing that this situation required observation rather than intervention. Court Clerk Olivia Bradford watched with growing amazement as Simone reached into her briefcase, not frantically or defensively, but with the measured precision of someone executing a long-planned strategy. The leather case that Olivia had assumed contained standard court reporting supplies suddenly seemed to hold far more significance. In the gallery, the plaintiffs who had traveled from across Chicago to witness this proceeding sat transfixed. They had come seeking justice for systematic discrimination, and now they were witnessing something that felt like divine intervention. Maria Rodriguez, the nurse who had been denied her mortgage, felt tears welling in her eyes as she watched this black woman face down the same kind of arrogance she had encountered at Midwest Financial. Attorney Jennifer Martinez, representing the federal government, realized she was witnessing something unprecedented in her 6 years of prosecution. The careful way Simone was handling the situation suggested training and experience that went far beyond court reporting. Martinez found herself leaning forward, her prosecutorial instincts telling her that everything was about to change. Even defense counsel Nathan Pierce felt a chill of recognition. He had worked enough federal cases to understand courthouse hierarchy and protocol, and something about Simone's behavior was triggering warning bells. The woman Preston had just insulted was moving with the confidence of someone who held real authority in this building. But Preston Kingsley, drunk on his own arrogance and convinced of his superiority, interpreted Simone's silence as vindication. He had put her in her place, established his dominance, and demonstrated to everyone present that he was the most important person in the room. In his mind, the morning's performance had been flawless. "Now that we've established proper courtroom decorum," he said with satisfied smugness, "perhaps we can proceed with actual legal business when the judge arrives." The irony of his words would soon become devastatingly apparent. Simone opened her briefcase and removed a folded black garment that initially appeared to be a jacket or blazer. But as she shook it out, the distinctive collar and flowing sleeves revealed its true nature: a federal judicial robe, the symbol of ultimate authority in the American legal system. Several attorneys in the courtroom began to understand what they were witnessing. The careful way Simone handled the robe, the respectful silence that had fallen over the court staff, the growing sense of anticipation in the air, all pointed to a revelation that would redefine everything about this morning's proceedings. Olivia Bradford, who had been managing this courtroom's docket for 8 years, suddenly realized why the morning's scheduling had been so unusual. The case file she had prepared listed Judge S. Whitmore as the presiding jurist, but she had assumed it was Judge Samuel Whitmore from the Northern District. The possibility that it could be Simone Whitmore, the woman Preston had just systematically humiliated, had never occurred to her. Marcus Sterling's military bearings straightened as understanding dawned. He had been briefed that morning about enhanced security for a high-profile discrimination case, but the details about the presiding judge had been kept confidential. Now he realized why, and his respect for the woman he was sworn to protect reached new levels. In the gallery, whispers began to ripple through the crowd as people started to grasp what was happening. These were families who had been dismissed, ignored, and discriminated against by institutions they had trusted. Now they were witnessing one of those institutions' representatives face consequences for his prejudice in real time. Preston Kingsley, however, remained oblivious to the transformation occurring around him. He was reviewing his opening arguments, confident that his morning's performance had established the proper hierarchy for the proceedings. When the actual judge arrived, Kingsley was certain his authority and competence would be recognized and respected. As Simone Whitmore prepared to don her judicial robe, she paused for one final moment to observe the man who had just provided her with the most compelling evidence of institutional bias she had encountered in decades of fighting discrimination. But when the real judge was supposed to enter, something happened that no one in that courtroom could have predicted, because the quiet woman Preston had spent the morning insulting was about to reveal a truth that would destroy everything he believed about power, privilege, and justice. At exactly 10:20 a.m., the appointed time for court to convene, something unprecedented happened in courtroom 2305. Instead of a bailiff announcing the judge's entrance, instead of the traditional all-rise that signaled the beginning of proceedings, Simone Whitmore simply stood and began putting on her judicial robe. The transformation was breathtaking in its quiet dignity. As the black silk settled over her shoulders, decades of authority and experience became visible. This wasn't a woman playing dress-up or making a statement. This was a federal judge, assuming her rightful position, a position she had held with distinction for over 15 years. The first person to understand was Marcus Sterling. As the courtroom bailiff, he had been briefed on security protocols for Judge Whitmore's cases, but her decision to observe the morning's interactions incognito had been kept confidential. Now watching her assume her judicial authority, he felt a mixture of professional admiration and personal satisfaction. The woman Preston Kingsley had spent an hour systematically insulting was about to demonstrate exactly what real power looked like. Court clerk Olivia Bradford felt her breath catch as the pieces fell into place. Judge Simone Whitmore's reputation preceded her throughout the federal system. A brilliant jurist, known for her fairness, her thorough understanding of constitutional law, and her particular expertise in civil rights cases. She had authored landmark decisions on employment discrimination, housing rights, and institutional bias that had been cited by appellate courts across the nation. But more than her legal scholarship, Judge Whitmore was known for something else: her absolute intolerance for discrimination in any form. Attorneys who appeared before her learned quickly that racist, sexist, or classist behavior would be met with swift and decisive consequences. Her courtroom was a place where justice was blind to everything except the law and the facts. As Simone fastened the robe and moved toward the judge's bench, Preston Kingsley finally looked up from his notes. For a moment, his brain couldn't process what he was seeing. The woman he had dismissed as an incompetent court reporter was wearing judicial robes and approaching the bench with the unmistakable authority of someone who belonged there. "What's she doing?" he whispered to his associate, who was staring in open-mouthed horror at the unfolding scene. Around the courtroom, the reality of the situation began to dawn on everyone present. The plaintiffs in the gallery, who had come seeking justice for discrimination, realized they were witnessing something extraordinary, one of their own assuming the ultimate position of authority in the American legal system. Jennifer Martinez, the federal prosecutor, felt a surge of professional excitement mixed with personal vindication. She had argued cases before Judge Whitmore before, and knew her reputation for fairness and constitutional expertise. Having witnessed Preston's behavior, Martinez realized that justice was about to be served in the most poetic way possible. But it was the gallery's reaction that truly captured the magnitude of the moment. Maria Rodriguez, the nurse who had been denied her mortgage, began to weep quietly as she watched a black woman assume the bench. For someone who had been dismissed and discriminated against by financial institutions, seeing Simone Whitmore take her position as a federal judge felt like divine intervention. James Washington, the teacher whose loan application had been rejected, felt something he hadn't experienced in years: hope. He had come to court expecting another system designed to protect those who had discriminated against him. Instead, he was witnessing that system's ultimate authority being assumed by someone who understood his experience intimately. Elderly Mrs. Patterson, the woman who had struggled to find a seat earlier, clutched her walker and whispered, "Thank you, Jesus," as she realized that the morning's proceedings would be overseen by someone who had faced the same dismissive treatment she had endured her entire life. As Simone reached the bench, she paused and turned to address the courtroom. Her voice, when she spoke, carried the clear authority of 15 years on the federal bench and 3 decades in the legal profession. "Ladies and gentlemen," she began, her words resonating through the marble chamber, "Court is now in session in the matter of United States of America versus Midwest Financial Corporation." The formal words, spoken with quiet dignity, hit Preston Kingsley like a physical blow. The woman he had spent the morning insulting, dismissing, and demeaning was the federal judge assigned to hear his case. Every condescending comment, every racist assumption, every moment of arrogance had been observed and documented by the one person in Chicago with the power to hold him accountable. His face went ashen as the full implications of his behavior began to register. This wasn't just embarrassing, it was potentially career-ending. Federal judges had broad discretion in managing their courtrooms, and his conduct had violated every principle of professional behavior and human decency. As Judge Whitmore settled into her chair, and surveyed the courtroom with the calm authority of someone who had presided over thousands of cases, Preston Kingsley realized that everything he thought he knew about power, privilege, and justice was about to be completely overturned. As the truth began to unfold, Preston's world started crumbling around him in ways he never could have imagined. The moment Judge Simone Whitmore assumed the bench, the entire dynamic of Courtroom 2305 shifted dramatically. What had been Preston Kingsley's stage for demonstrating his superiority became a tribunal where his behavior would be scrutinized by the most qualified person to judge its appropriateness. "Mr. Sterling," Judge Whitmore addressed the bailiff with the familiar authority of someone who had worked with him on dozens of cases, "please ensure that all parties are ready to proceed." Marcus Sterling snapped to attention, his military bearing reflecting both professional respect and personal admiration for the judge who had just endured an hour of systematic insults with unshakable dignity. "Yes, Your Honor. All counsel are present and the gallery is properly secured." The formal exchange between judge and bailiff served as confirmation for anyone still doubting what they were witnessing. This wasn't an elaborate performance or misunderstanding. Simone Whitmore was the duly appointed federal judge assigned to hear United States versus Midwest Financial Corporation, and she had chosen to observe the morning's proceedings from the court reporter's station. Preston Kingsley felt sweat beading on his forehead as the full implications of his behavior crashed over him like a tsunami. Every dismissive comment, every condescending gesture, every moment of racist and sexist arrogance had been directed at the one person in Chicago with ultimate authority over his client's fate and his own professional future. His associate, junior attorney Michael Crawford, looked physically ill as he realized that his firm's biggest case of the year was being presided over by a judge they had just systematically insulted. Crawford had tried to warn Preston about his behavior earlier, but his concerns had been dismissed with the same arrogance that had characterized the entire morning. "So, Your Honor," Preston stammered, rising unsteadily to his feet, we weren't aware." Judge Whitmore's gaze settled on him with the calm intensity of someone who had spent decades evaluating evidence and weighing testimony. Her expression revealed nothing. No anger, no vindictiveness, just the professional assessment of a jurist observing behavior that violated every principle of legal ethics and human decency. "Mr. Kingsley," she said quietly, her voice carrying clearly through the silent courtroom, "please remain standing." The simple command, delivered with judicial authority, sent a chill through everyone present. In federal court, judges didn't ask attorneys to remain standing unless they were about to address serious misconduct. Around the courtroom, the implications of the morning's events were becoming clear to everyone. Jennifer Martinez, the federal prosecutor, realized she was witnessing something unprecedented. A federal judge who had personally observed discriminatory behavior that perfectly illustrated the institutional bias her case was designed to address. In the gallery, the plaintiffs who had been denied mortgages by Midwest Financial felt a surge of vindication. They had been dismissed, belittled and discriminated against by financial institutions that assumed they lacked the power to fight back. Now they were watching one of those institutions' representatives face the consequences of that same arrogance. Olivia Bradford, the court clerk, felt professional pride mixed with personal satisfaction as she watched Judge Whitmore handle the situation with perfect judicial temperament. She had seen other judges lose their composure when faced with far less egregious behavior. But Judge Whitmore's response demonstrated exactly why she was considered one of the most respected jurists in the Northern District. "Mr. Kingsley," Judge Whitmore continued, "before we address the substantive matters in this case, I believe we need to discuss your conduct this morning. Are you aware that your comments and behavior have been observed by this court?" The question was rhetorical, but it forced Preston to confront the reality of his situation publicly. He had assumed he was performing for an audience of peers and subordinates, demonstrating his superiority and authority. Instead, he had been auditioning for professional destruction in front of the one person with the power to end his career. "Your Honor," he began, his voice cracking with desperation, "I sincerely apologize for any misunderstanding. I had no idea that you were... That is, I didn't realize..." That I was what, Mr. Kingsley? Judge Whitmore's question cut through his stammering with surgical precision. That I was the judge assigned to this case, that I was qualified to understand complex legal proceedings, that I deserved the basic respect accorded to every person in this courtroom? Each question landed like a physical blow, exposing the assumptions and prejudices that had driven his behavior. Preston's face flushed as he realized that any answer he gave would only make his situation worse. The courtroom remained completely silent as Judge Whitmore allowed the weight of his behavior to settle over everyone present. She had spent decades fighting institutional discrimination through legal scholarship and judicial decisions, but rarely had she been presented with such a clear example of the attitudes that perpetuated systemic bias. "Mr. Kingsley," she said finally, "your behavior this morning has provided this court with valuable insight into the institutional attitudes that give rise to cases like the one we're here to address today. But this was only the beginning of Preston's nightmare, because what Judge Whitmore was about to reveal would destroy not just his reputation, but everything he thought he knew about power, privilege, and accountability." Judge Simone Whitmore's words hung in the air like a judicial gavel, but she wasn't finished. The morning's events had provided her with something no amount of legal briefs could offer: a live demonstration of the discriminatory attitudes that her court was designed to address. "The record should reflect," she continued, her voice carrying the authority of 15 years on the federal bench, "that this court has observed firsthand the type of institutional bias that forms the foundation of the case before us today." Preston Kingsley felt his knees weaken as he realized that his behavior wasn't just being noted for potential disciplinary action, it was being incorporated into the legal record of United States v. Midwest Financial Corporation. His racist and sexist comments would become part of the permanent federal court record, available to appellate courts, legal scholars, and anyone researching discrimination in the legal profession. But Judge Whitmore was just getting started. Her decision to observe the morning's proceedings incognito hadn't been impulsive. It had been strategic, based on decades of experience fighting institutional discrimination and a growing concern about bias in her own courthouse. "For the benefit of all parties," she said, "I believe some context is necessary. Over the past 6 months, this court has received numerous complaints about discriminatory treatment of court staff, plaintiffs, and even attorneys in this building. These complaints have alleged a pattern of bias based on race, gender, and perceived social status." Jennifer Martinez, the federal prosecutor, felt her pulse quicken. She had filed some of those complaints herself, documenting instances where defense attorneys had treated minority witnesses, court personnel, and even her own staff with obvious disrespect. She had suspected that the problem was more widespread than individual incidents, but proving institutional bias required evidence that was difficult to obtain. Rather than rely solely on second-hand reports, Judge Whitmore continued, this court decided to observe interactions firsthand. The court reporting station provided an ideal vantage point from which to assess whether the alleged patterns of discrimination were indeed occurring. The brilliance of her strategy was becoming apparent to everyone in the courtroom. By positioning herself as a court reporter, someone typically invisible to arrogant attorneys, she had created conditions where discriminatory behavior would be displayed without pretense or concealment. In the gallery, the plaintiffs who had been denied mortgages by Midwest Financial realized they were witnessing something extraordinary. They had come to court seeking justice for systematic discrimination, and now they were watching that same discrimination being exposed and addressed at the highest levels of the federal judiciary. Maria Rodriguez, the nurse whose mortgage application had been rejected despite excellent credit, felt tears streaming down her cheeks as she watched Judge Whitmore methodically dismantle the institutional bias that had affected her own life. The condescending treatment she had received from loan officers at Midwest Financial was being mirrored by Preston's behavior, and now both were being addressed by someone with the power to create lasting change. "The evidence gathered during this morning's observation," Judge Whitmore continued, "confirms that discriminatory attitudes persist within Chicago's legal community. Mr. Kingsley's behavior toward court staff, his dismissive comments about the plaintiffs in this case, and his assumption that authority correlates with appearance rather than qualifications all demonstrate the institutional mindset that enables systematic discrimination. Preston Kingsley's face had gone from red to ashen as he realized the full scope of his predicament. This wasn't just about his morning's behavior. It was about a pattern of institutional bias that Judge Whitmore had been documenting for months. His comments hadn't just been inappropriate, they had provided evidence for a broader investigation into discrimination within the legal profession. Defense counsel Nathan Pierce felt sick to his stomach as he realized his own complicity in enabling Preston's behavior. He had witnessed similar comments in private conversations, during strategy meetings and in casual interactions with court staff. His failure to address that behavior had contributed to an environment where discrimination flourished unchecked. Furthermore, Judge Whitmore added, her voice carrying the weight of judicial authority, Mr. Kingsley's assumption that this court lacked the education and experience to handle complex federal litigation reveals precisely the kind of bias that prevents qualified individuals from receiving equal treatment under law. The irony was devastating. Preston had questioned Judge Whitmore's qualifications while standing before one of the most accomplished jurists in the federal system. Her resume included Harvard Law School, clerking for a Supreme Court justice, 15 years of distinguished service on the federal bench, and authorship of landmark civil rights decisions that had been cited by courts nationwide. Court clerk Olivia Bradford pulled up Judge Whitmore's biographical information on her computer screen, preparing to reference her qualifications if needed. The list was impressive. Graduated magna cum laude from Harvard Law, served as editor of the Harvard Law Review, clerked for Justice Thurgood Marshall, spent 10 years in civil rights practice before her judicial appointment, authored over 200 published opinions, including several landmark discrimination cases, and received numerous awards for her contribution to civil rights jurisprudence. Your Honor, Preston attempted desperately, I want to offer my sincerest apologies. My comments were completely inappropriate and don't reflect my true beliefs or the values of my firm. But Judge Whitmore's expression remained unchanged. She had heard similar apologies countless times, usually after discriminatory behavior had been exposed, never before it occurred. The pattern was always the same: arrogance followed by exposure, followed by desperate attempts at damage control. Mr. Kingsley, she replied calmly, your apology is noted for the record. However, this court is more interested in addressing the institutional patterns that enable such behavior than in evaluating individual expressions of remorse. The distinction was crucial. Judge Whitmore wasn't conducting a personal vendetta against Preston Kingsley. She was using his behavior as evidence of broader systemic problems that required institutional solutions. Marcus Sterling, the bailiff, felt professional pride as he watched Judge Whitmore handle the situation with perfect judicial temperament. He had served in her courtroom for 3 years and had never seen her lose her composure, raise her voice, or allow personal feelings to influence her judicial decisions. Even now, after enduring systematic insults and discrimination, she was responding with the measured authority that had earned her respect throughout the federal system. The court notes, Judge Whitmore continued, that Mr. Kingsley's behavior this morning occurred in the presence of multiple witnesses, including court staff, attorneys, and the plaintiffs whose rights are at issue in this case. This provides valuable context for understanding how institutional discrimination operates in practice. In the gallery, elderly Mrs. Patterson, the woman who had struggled to find a seat earlier, felt a lifetime of experiences being validated. She had endured decades of dismissive treatment from lawyers, bank officers, government officials, and others who assumed her age, race, and economic status made her opinions irrelevant. Now she was watching one of those officials face consequences for exhibiting the same attitudes that had affected her throughout her life. What they discovered about Preston's past would shock the entire legal community and reveal a pattern of discrimination that reached far beyond this single morning. Judge Whitmore reached beneath her bench and retrieved a thick manila folder that she placed deliberately on the judicial podium. The file was marked Confidential Judicial Conduct Investigation, and its presence sent a wave of apprehension through the courtroom. Preston Kingsley's morning of arrogance had just become part of a much larger investigation. Mr. Kingsley, Judge Whitmore said, opening the folder with practiced precision, this court has been conducting a comprehensive review of discriminatory practices within Chicago's legal community. Your behavior this morning provides compelling evidence that supports complaints filed by 17 different individuals over the past 8 months. The number hit Preston like a physical blow. 17 complaints meant 17 witnesses to behavior similar to what the courtroom had observed. It meant a pattern of discrimination so consistent that it had attracted the attention of the federal judiciary's internal oversight mechanisms. Jennifer Martinez, the federal prosecutor, realized she was witnessing the convergence of multiple investigations. Her case against Midwest Financial for discriminatory lending practices was being supported by evidence of discriminatory attitudes within the legal profession itself. The institutional bias that had denied mortgages to qualified minority applicants was the same mindset that had led Preston to assume Judge Whitmore was unqualified based on her appearance. The complaints, Judge Whitmore continued, include incidents of racist and sexist language directed toward court staff, dismissive treatment of minority attorneys, and assumptions about individuals' qualifications based on their race, gender, or perceived economic status. Mr. Kingsley's name appears in connection with 7 of these incidents. 7 incidents. Preston felt his career flashing before his eyes as he realized that his morning's behavior wasn't an isolated mistake. It was the latest example in a documented pattern of discrimination that had been building a case against him for months. His associate, Michael Crawford, discreetly opened his laptop and began researching ethical violation procedures, professional discipline standards, and potential consequences for systematic discriminatory behavior. What he found made his stomach drop. The Illinois State Bar Association's rules provided for suspension or disbarment for patterns of conduct that brought the legal profession into disrepute. Around the courtroom, attorneys who had witnessed Preston's behavior began to understand the broader implications. This wasn't just about one lawyer's inappropriate comments. It was about institutional accountability and the legal profession's responsibility to police discriminatory conduct within its own ranks. Furthermore, Judge Whitmore added, consulting her notes, this court has received reports that Mr. Kingsley's firm, Pemberton, Ashworth & Associates, has been the subject of multiple discrimination complaints from both clients and employees. The Equal Employment Opportunity Commission has opened a formal investigation into the firm's hiring and promotion practices. The revelation sent shockwaves through the legal community representatives present in the courtroom. Pemberton, Ashworth & Associates was one of Chicago's most prestigious corporate law firms, representing major financial institutions, Fortune 500 companies, and government entities. An EOC investigation would scrutinize every aspect of their employment practices and could result in massive financial penalties and reputational damage. In the gallery, the plaintiffs who had been denied mortgages by Midwest Financial felt a surge of vindication. They had been told that their loan denials were based on objective financial criteria, but now they were seeing evidence that the attitudes driving those decisions were rooted in the same discriminatory mindset that Preston had displayed. Court reporter, the real court reporter who had been scheduled for the afternoon session, slipped quietly into the courtroom and took her position at the stenotype machine. The irony wasn't lost on anyone. Preston had spent the morning questioning Judge Whitmore's qualifications to document legal proceedings, and now his words were being transcribed by someone whose sole job was to create an accurate record of his professional destruction. Mr. Kingsley, Judge Whitmore said, her voice carrying the finality of judicial decision, this court finds that your conduct this morning demonstrates a pattern of discriminatory behavior that undermines the integrity of these proceedings and the administration of justice. The formal language was devastating in its precision. Judge Whitmore wasn't just criticizing Preston's behavior. She was making findings that would become part of the permanent federal court record and could be used in subsequent disciplinary proceedings. Marcus Sterling noticed that several people in the gallery were recording the proceedings on their phones. By evening, Preston's humiliation would be shared across social media platforms, legal professional networks, and civil rights organizations nationwide. His morning of arrogance was becoming a viral demonstration of how institutional discrimination operated and how it could be held accountable. The court will be referring this matter to the Illinois Attorney Registration and Disciplinary Commission for formal investigation, Judge Whitmore announced. Additionally, copies of this morning's transcript will be forwarded to the Equal Employment Opportunity Commission as part of their ongoing investigation into discriminatory practices at Pemberton, Ashworth and Associates. But what Judge Whitmore did next would ensure Preston never practiced law the same way again, because her final decision would create consequences that reached far beyond his individual career. Judge Whitmore's announcement about referring Preston's conduct to disciplinary authorities was just the beginning. As a federal judge with broad discretion over courtroom management and case administration, she possessed immediate powers that could be exercised without waiting for lengthy investigative processes. "Mr. Kingsley," she continued, her voice carrying the full weight of federal judicial authority, "this court finds that your conduct this morning has compromised your ability to effectively represent your client in these proceedings. Your demonstrated bias against the plaintiffs in this case creates an irreconcilable conflict of interest that undermines the integrity of the adversarial process." The words hit Preston like a sledgehammer. Judge Whitmore was questioning his ability to represent Midwest Financial, not just his conduct, but his fundamental fitness to serve as an attorney in a discrimination case where he had demonstrated the very attitudes that were being litigated. Jennifer Martinez, the federal prosecutor, felt a surge of professional excitement as she realized the implications. If Preston were removed from the case, Midwest Financial would need to find new counsel, potentially delaying proceedings for months, while new attorneys familiarized themselves with 2 years of complex litigation. The disruption alone would cost his firm hundreds of thousands of dollars and damage their reputation with a major client. "Your Honor," Preston stammered desperately, "I assure you that my inappropriate comments this morning won't affect my professional representation of my client's interests." But Judge Whitmore's expression indicated that his protestations were falling on deaf ears. She had spent decades observing how bias affected legal representation, how discriminatory attitudes colored attorneys' strategies, witness examinations, and interactions with opposing counsel. "Mr. Kingsley," she replied calmly, "your treatment of this court and the court staff this morning demonstrates a fundamental disrespect for the judicial process. Your dismissive comments about the plaintiffs in this case suggest that you view them as unworthy of equal protection under law. These attitudes are incompatible with the ethical obligations that govern legal representation in federal civil rights litigation." Around the courtroom, the implications of Judge Whitmore's reasoning became clear. Preston hadn't just made inappropriate comments, he had revealed attitudes that would affect every aspect of his representation, from jury selection to witness examination to closing arguments. In the gallery, Maria Rodriguez felt her heart racing as she realized that the lawyer representing the bank that had discriminated against her was being held accountable for exhibiting the same discriminatory attitudes. The institutional bias that had denied her a mortgage was being exposed and addressed at the highest levels of the federal judiciary. Furthermore, Judge Whitmore continued, "This court has concerns about Mr. Kingsley's ability to conduct respectful cross-examinations of the minority plaintiffs in this case. Given his demonstrated bias, the court cannot ensure that these individuals will receive fair treatment during testimony." The practical implications were devastating. Cross-examination was a crucial part of Midwest Financial's defense strategy, and Preston had been preparing for months to challenge the plaintiff's testimony. Now his own behavior had disqualified him from that central role. Michael Crawford, Preston's associate, realized that he was witnessing the complete destruction of his mentor's career in real time. The case they had been working on for 2 years, the client relationship that generated millions in fees, the reputation that had taken decades to build, all of it was crumbling because of one morning's arrogant behavior. "Therefore," Judge Whitmore announced, "this court hereby orders that Mr. Kingsley is removed as counsel of record for defendant Midwest Financial Corporation. The defendant will have 30 days to retain new counsel before these proceedings continue." The gavel came down with finality that echoed through the marble chamber. Preston Kingsley had been removed from the biggest case of his career in front of colleagues, clients, and the media because of his racist and sexist behavior toward the judge presiding over the case. But Judge Whitmore wasn't finished. Her experience fighting institutional discrimination had taught her that individual accountability was meaningless without systemic change. Additionally, she continued, this court will be implementing new protocols for monitoring attorney conduct during federal civil rights litigation. All proceedings in discrimination cases will be recorded, and patterns of biased behavior will be documented and reported to appropriate disciplinary authorities. The announcement sent ripples through Chicago's legal community. Judge Whitmore was using Preston's behavior as a catalyst for institutional reform that would affect how discrimination cases were litigated throughout the Northern District of Illinois. Court clerk Olivia Bradford began taking notes on the new protocols, realizing that she was witnessing the birth of policies that would protect court staff, attorneys, and litigants from discriminatory treatment for years to come. Marcus Sterling felt professional pride as he watched Judge Whitmore transform a morning of ugliness into an opportunity for systemic improvement. Her response to Preston's behavior demonstrated exactly why she was considered one of the most effective civil rights advocates on the federal bench. The consequences were just beginning to unfold, and what came next would change the federal court system permanently and ensure that Preston's career would never recover from his morning of arrogance. As news of Preston Kingsley's removal from the Midwest financial case spread through the courthouse, the reverberations extended far beyond courtroom 2305. Judge Whitmore's decisive action was sending shockwaves through Chicago's legal establishment, and the institutional changes she was implementing would have lasting consequences for how federal civil rights litigation was conducted. Within hours, the story had reached the offices of the Illinois State Bar Association. Ethics investigators who had been tracking complaints about discriminatory behavior in Chicago's legal community realized that Judge Whitmore had provided them with the most compelling evidence they had ever received. Her first-hand observations, combined with the documented pattern of complaints, created an ironclad case for disciplinary action. Sarah Chen, Director of Professional Responsibility for the Illinois State Bar, received the formal complaint about Preston's conduct with a mixture of professional satisfaction and personal vindication. She had been fighting institutional bias within the legal profession for over a decade, but proving systematic discrimination required evidence that was often difficult to obtain. Judge Whitmore's strategic observation had provided exactly the kind of documentation that could support meaningful disciplinary action. At Pemberton, Ashworth and Associates, the firm's managing partners were conducting emergency meetings to assess the damage to their reputation and client relationships. Preston's removal from the Midwest financial case meant the loss of a multi-million-dollar client, but the broader implications were even more concerning. If the EEOC investigation revealed systematic discrimination within their employment practices, the firm could face massive financial penalties and permanent reputational damage. Senior partner Jonathan Pemberton, whose grandfather had founded the firm in 1923, felt the weight of 3 generations of legal tradition being threatened by one attorney's arrogant behavior. The firm's client list included some of Chicago's most prestigious corporations, and news of discrimination investigations would make those clients question their continued association with Pemberton, Ashworth and Associates. But the impact extended beyond individual firms and attorneys. Judge Whitmore's decision to implement new monitoring protocols for civil rights cases was being noticed by federal judges throughout the Northern District and beyond. Her approach, using direct observation to document discriminatory behavior, was being discussed as a model for addressing institutional bias within the federal court system. Judge Patricia Morrison, who presided over employment discrimination cases in the adjacent courtroom, had already begun implementing similar observation protocols in her own proceedings. She had received numerous complaints about attorney conduct over the years, but proving discriminatory behavior required evidence that was often difficult to obtain. Judge Whitmore's strategy provided a practical method for documenting and addressing institutional bias. The Federal Judicial Conference, the policy-making body for the federal court system, took notice when Judge Whitmore's order was circulated among federal judges nationwide. Her innovative approach to addressing discrimination was being studied as a potential model for implementation in other districts where similar problems had been reported. In the gallery of Courtroom 2305, the plaintiffs who had been denied mortgages by Midwest Financial were experiencing something many had never felt before: institutional validation of their experiences. For years, they had been told that their loan denials were based on objective financial criteria, but now they were seeing evidence that discriminatory attitudes had influenced those decisions. James Washington, the teacher whose mortgage application had been rejected, felt tears in his eyes as he watched the institutional bias that had affected his life being addressed at the highest levels of the federal judiciary. He had been dismissed, patronized, and discriminated against by financial institutions that assumed he lacked the power to fight back. Now he was witnessing one of those institutions' representatives face real consequences for exhibiting the same attitudes. Maria Rodriguez realized that Judge Whitmore's actions were creating precedents that would protect future victims of discrimination. The new monitoring protocols, the documentation of attorney misconduct, the institutional accountability, all of it represented systemic changes that would make discrimination more difficult to practice and easier to prove. But perhaps the most significant impact was on the broader civil rights community. News of Judge Whitmore's handling of Preston's behavior was spreading through social media, professional networks, and advocacy organizations. Her demonstration that institutional discrimination could be exposed, documented, and addressed was inspiring similar efforts in other jurisdictions. Dr. Angela Thompson, director of the Chicago Urban League, received updates about the morning's proceedings with professional excitement and personal satisfaction. She had been documenting discriminatory practices in Chicago's financial and legal communities for years, but proving institutional bias required evidence that was often difficult to obtain. Judge Whitmore's strategic approach provided a model for holding discriminatory institutions accountable. The National Association for the Advancement of Colored People announced that it would be filing formal complaints about discriminatory practices in federal courts nationwide, using Judge Whitmore's documentation methods as a template for gathering evidence of institutional bias. But the transformation this moment created would last forever, inspiring changes in how federal courts address discrimination and establishing precedents that would protect civil rights for generations to come. 6 months after the events in Courtroom 2305, the ripple effects of Judge Whitmore's handling of Preston Kingsley's discriminatory behavior had transformed Chicago's legal landscape and inspired similar reforms across the federal court system. Preston Kingsley's legal career had effectively ended that Tuesday morning in Judge Whitmore's courtroom. The Illinois Attorney Registration and Disciplinary Commission had suspended his law license for 2 years following their investigation into his pattern of discriminatory conduct. The 7 complaints that Judge Whitmore had referenced in court had been supplemented by 12 additional complaints from former clients, opposing attorneys, and court staff who had been inspired by Judge Whitmore's example to come forward with their own experiences. The suspension wasn't just administrative, it was accompanied by a requirement that Preston complete extensive bias training, perform 500 hours of community service with civil rights organizations, and undergo evaluation by psychological professionals specializing in discriminatory behavior. The Disciplinary Commission's report, which became public record, documented a pattern of racist and sexist conduct that made Preston virtually unemployable in Chicago's legal community. Pemberton, Ashworth and Associates faced even more severe consequences. The Equal Employment Opportunity Commission's investigation had revealed systematic discrimination in hiring, promotion, and compensation practices that violated federal civil rights laws. The firm was required to pay $3 million in settlements to current and former employees who had faced discrimination, implement comprehensive diversity training programs, and submit to 5 years of federal monitoring. More significantly, the negative publicity had cost the firm several major clients, including 3 Fortune 500 companies that terminated their legal services contracts, rather than be associated with discriminatory practices. The firm's revenues dropped by 40% in the first year following the scandal, forcing layoffs and a complete restructuring of their business model. But the positive changes were even more significant than the individual consequences. Judge Whitmore's monitoring protocols had been adopted by federal courts in 12 districts across the country, creating systematic documentation of attorney conduct in civil rights cases. The Federal Judicial Conference had established a national database for tracking discriminatory behavior by attorneys, making it impossible for lawyers to escape accountability by moving between jurisdictions. The monitoring system had already produced impressive results. In the first 6 months of implementation, documented instances of discriminatory behavior dropped by 60% in participating courts. Attorneys who had previously made racist, sexist, or classist comments with impunity realized that their conduct was being observed and recorded by judicial staff trained to recognize bias. More importantly, the documentation was being used proactively to address institutional problems before they became individual tragedies. Law schools were incorporating the monitoring data into their professional responsibility curricula, teaching future attorneys about the practical consequences of discriminatory behavior. The American Bar Association had established the Simone Whitmore Award for Judicial Excellence in Civil Rights, recognizing federal judges who demonstrated innovative approaches to addressing institutional discrimination. Judge Whitmore herself had received the award's inaugural recognition, cementing her reputation as one of the most effective civil rights advocates in the federal judiciary. But perhaps the most meaningful changes were occurring at the individual level. Maria Rodriguez, the nurse whose mortgage application had been denied by Midwest Financial, had received a formal apology from the bank's new leadership and had been approved for a mortgage at favorable terms. More significantly, she had been inspired by Judge Whitmore's example to pursue legal education herself, enrolling in night classes at Chicago-Kent College of Law with the goal of becoming a civil rights attorney. James Washington, the teacher whose loan application had been rejected, had not only received his mortgage, but had been hired by the Chicago Public Schools to develop curriculum about civil rights and institutional accountability. His program, Justice in Action, taught high school students about how discriminatory attitudes could be challenged and overcome through systematic documentation and institutional reform. Elderly Mrs. Patterson, who had struggled to find a seat in the courthouse gallery, had become an advocate for elderly rights and accessibility in federal buildings. Her testimony before Congress about age discrimination had contributed to new federal guidelines requiring improved accommodation for elderly and disabled court users. The plaintiffs in the Midwest Financial case had achieved more than financial compensation. They had witnessed institutional change that would protect future generations from the discrimination they had experienced. The new monitoring protocols ensured that their experiences would be documented, their voices would be heard, and their rights would be protected by systematic accountability measures. Judge Whitmore herself had been elevated to the Court of Appeals for the Seventh Circuit, where her innovative approaches to addressing institutional discrimination were being implemented on a regional scale. Her confirmation hearing had been notable for the unanimous support she received from civil rights organizations, legal professional associations, and judicial reform advocates. What happened next would surprise everyone who thought the story was over, because Judge Whitmore's final decision would create a legacy that lasted decades and inspired a new generation of civil rights advocates. Stories of justice and dignity, like Judge Whitmore's, inspire people all around the world. Let us know what country and city you're watching from, so we can see how far these powerful messages of standing up against discrimination are reaching. 2 years after that transformative Tuesday morning in courtroom 2305, Judge Simone Whitmore stood before a packed auditorium at Harvard Law School, delivering the annual Civil Rights Lecture to an audience of law students, practicing attorneys, and federal judges from across the country. The irony wasn't lost on anyone present. She was speaking from the same institution where she had first learned about justice, to an audience that included many who had been inspired by her handling of institutional discrimination. "The morning I sat at that court reporter's desk," she began, her voice carrying the same quiet authority that had commanded respect in federal courtrooms for over a decade. I wasn't trying to create a viral moment or generate headlines. I was simply trying to understand how bias operates when people think they're not being observed. The audience, which included Maria Rodriguez, now in her second year of law school, listened with rapt attention as Judge Whitmore described the strategic thinking behind her decision to observe courtroom interactions incognito. What I discovered that morning confirmed what civil rights advocates have been saying for decades. Discrimination thrives in environments where people believe their behavior won't have consequences. The moment we create accountability, real systematic institutional accountability, discriminatory behavior becomes much more difficult to practice and much easier to address. In the audience, James Washington felt pride as he watched the woman whose courage had inspired his own transformation into a civil rights educator. His Justice in Action curriculum had been adopted by school districts in 15 states, teaching young people that institutional change was possible when individuals had the courage to document and challenge discriminatory behavior. Judge Whitmore's lecture was being live-streamed to federal courthouses, law schools, and civil rights organizations nationwide. The monitoring protocols she had pioneered had been adopted by federal courts in all 50 states, creating the most comprehensive system for documenting and addressing attorney misconduct in American legal history. The results had been remarkable. Complaints about discriminatory behavior in federal civil rights cases had dropped by 75% in the 2 years since implementation. More importantly, the documentation was being used proactively to identify and address institutional problems before they caused individual harm. But the most significant outcome, Judge Whitmore continued, wasn't the individual consequences for one attorney's behavior. It was the demonstration that institutional change is possible when we have the courage to confront bias directly and systematically. The Preston Kingsley case had become a teaching tool in law schools across the country, used to demonstrate how individual actions could create institutional consequences and how systematic documentation could expose patterns of discrimination that might otherwise remain hidden. Preston himself had completed his suspension and bias training, but his legal career had never recovered. The documented pattern of discriminatory behavior made him unemployable at major firms, and his attempts to establish independent practice had been unsuccessful. More significantly, the psychological evaluation required by his disciplinary action had revealed underlying attitudes that required ongoing therapy and personal development work. In a surprising development, Preston had voluntarily enrolled in a master's program in social work, with a focus on addressing institutional bias in professional settings. His personal transformation, while painful and costly, had become part of the broader story about how institutional accountability could create individual change. The question we must ask ourselves, Judge Whitmore concluded, is not whether discrimination still exists in our institutions. The question is whether we have the courage to create systems that document, expose, and address that discrimination when it occurs. The standing ovation that followed lasted for over 5 minutes, but Judge Whitmore's attention was focused on the young faces in the audience, law students who would inherit the institutions she had worked to reform, who would face their own moments of choice between complicity and courage. After the lecture, Maria Rodriguez approached Judge Whitmore with the confidence of someone who had learned that justice was possible when individuals had the courage to pursue it. "Your Honor," she said, "I wanted to thank you for showing me that one person's courage can create institutional change. I'm planning to specialize in civil rights law, and I hope to continue the work you started." Judge Whitmore smiled, remembering the determined nurse who had sat in the courthouse gallery 2 years earlier, seeking justice for discrimination she had experienced. "The work is never finished, Maria," she replied. "But every generation of advocates builds on the foundation created by those who came before. Your generation will face new challenges and create new solutions that we can't even imagine yet." As the evening ended and the crowd dispersed, Judge Whitmore reflected on the unexpected journey that had begun with one morning's strategic observation and had grown into a nationwide movement for institutional accountability. The individual consequences, Preston's career destruction, The firm's financial penalties, the documented pattern of discrimination, had been significant, but the systemic changes would protect countless individuals for generations to come. The monitoring protocols, the documentation systems, the accountability measures, all had grown from one federal judge's decision to sit quietly at a court reporter's desk and observe how power operated when people thought they weren't being watched. But most importantly, the story had demonstrated something that civil rights advocates had always known, but rarely been able to prove. Institutional change was possible when individuals had the courage to document injustice, challenge bias, and create accountability where none had existed before. Thank you to everyone who typed respect, and to all who shared their locations from around the world. Your global support for justice and dignity means everything. If stories like Judge Whitmore's inspire you to stand up against discrimination, please subscribe to join our community and help us share more incredible tales of courage and truth. Until next time, keep believing in the power of dignity over prejudice.